Now, this webinar is important in the criminal litigation paper because it is a separate procedure that is outlined in the course outline and that it is also appearing in the 2026 course outline. What is the procedure for extradition in Kenya? And if you know, can you give us a detailed explanation of the process? And this is where I can invite a member who at least has something to say on extradition before we embark, because the webinar is a short one and brief to the point and is of 28 pages. Members, what do you really understand by extradition? If this question is to come compulsory, what would you say in this question? What are the preliminary points that a student ought to understand before we jump straight in? I know why this question is difficult for you. It is because you have not conducted extradition proceedings in your course outline. But if you had been following through all of our sessions, we encountered questions to do with extradition, and I highlighted this part because I realized the challenge where I asked a student, there is a neighboring country known as Tanzania, and Tanzania is both in Commonwealth, and Tanzania is also having an exigency extradition treaty with Kenya. So there was a conflict of legislations where students were confused. Do you follow the Commonwealth Act or do you follow the Exigencies Act? And before we answer, it is important we understand the preliminaries. What is the meaning of extradition? Extradition is the formal legal process by which one state surrenders a person found within its territory to another state so that that person may 1. Stand trial for an extraditable offense, or serve or continue serving a sentence imposed after conviction. So I want you to understand extradition in two facets. Extradition, you can be coming for an accused person in a certain country, and the other situation is where it can also be a person who has already been convicted. Okay, and I also want you to appreciate what is the exact role of the DPP and the AG in this procedure, because in the two conflicting laws, conflicting in quotes, you need to understand clearly who does what and at what point. And you're also told that a person cannot lawfully be removed from Kenya merely because a foreign state has requested it. An Interpol red notice exists, a foreign arrest warrant has been circulated, and the person is a foreign national, or local police believe the person is wanted abroad. So the applicable Kenya extradition statute must be identified and followed. This is where I seek your indulgence in clearly understanding the Kenyan principal extradition laws before we start going into the nitty-gritties. Kenya has two principal extradition laws. You have Extradition, Contiguous and Foreign Countries Act, and you have Extradition, Commonwealth Countries Act Cap 77. So throughout this discussion, it is important to capture that Cap 76 will be making a reference to the Contiguous and Foreign Countries Act, and Cap 77 will be making a reference to Commonwealth Countries Act. So very important. And the principal distinction is the category of requesting state to which each applies, although their procedures and terminology also differ. So let us start with the key distinction between the two extradition statutes. Kenya's extradition framework is primarily governed by the Extradition, Contiguous and Foreign Countries Act Cap 76 and the Extradition Commonwealth Countries Act Cap 77. The main distinction between them is the category of requesting state to which each statute will be applicable, although they also define terminology, procedure, and statutory safeguards. We start with the countries covered in each statute. And Cap 76, now you see the basis of why I was saying you need to understand exactly what Cap 76 entails and what Cap 77 entails. You just master that Cap 77 is for Commonwealth countries. Cap 76 applies to foreign countries to which the Act has been extended through the prescribed extradition agreement and application mechanism. For Cap 76 to be invoked, two countries should have an extradition agreement, and a country does not fall under Cap 76 merely because it shares a border with Kenya. it can be Tanzania and Kenya, but if we don't have an extradition agreement, even if we share a border, it will not fall under CAP 76. Now, CAP 77 on the Commonwealth side, on the other hand, applies to Commonwealth countries that have been formally designated by an order made under Section 3 of that Act. And the other key distinction is on the legal basis. Extradition under CAP 76 is generally treaty and country specific, and the applicable extradition agreement and the relevant order may be containing particular conditions, exceptions, or even qualifications. But CAP 77, on the other hand, operates through statutory designation, and the designation order may similarly prescribe limitations, conditions, or modifications applicable to the country concerned. So this is just introduction so that you greatly appreciate the procedure. Persons sought are also different. CAP 76 uses the term fugitive criminal to describe a person accused or convicted of an extradition crime committed within the jurisdiction of the requesting state, while CAP 77 uses the term fugitive, which includes a person accused of an extradition offense or a person unlawfully at large after conviction. Nature of the offense. Under CAP 76, the relevant offense is described as an extradition crime. Whether an offense qualifies must be determined by reading the Act together with the applicable extradition agreement and order. But under CAP 77, the alleged conduct must satisfy the statutory definition of an extradition offense, including the applicable punishment threshold and the principle of dual criminality, meaning that the conduct must also constitute an offense under Kenyan law. Hapa be keen on the nature of the offense. Because you are told the nature of the offense for CAP 76, it will be determined by the reading of the Act together with the applicable extradition agreement. But on CAP 77, it should be also a conduct that also constitutes an offense under Kenyan law because it is focusing on the principle of dual criminality for Commonwealth countries. Now, commencement of proceedings is also different in both statutes. Under CAP 76, the requesting state submits a formal requisition through the prescribed diplomatic or statutory channel, after which the competent Kenyan authority may initiate the arrest and court process. But CAP 77, a formal request is made to the DPP, who may issue a written authority to proceed. Except in the case of a provisional warrant, proceedings ordinarily cannot continue without that authority. So this part is very important. This is why you distinguish between two people. We have the AG and we have the DPP. The AG, we have a famous decision that we will have to analyze part of the webinar that clearly distinguished between the role of the AG and the DPP. And it said that the role of the AG is limited to diplomatic functions or diplomatic situations. So if you look at CAP 76, where there is extradition treaty and agreements, this requesting state will submit a formal requisition through the AG as the prescribed diplomatic or statutory channel, after which the competent Kenyan authority may initiate the arrest and court procedure. Under CAP 77, a formal request is made to the DPP, who may issue a written authority to proceed. So take note of that quick distinction there, and that will be seen in one of the problem questions that we'll be beginning with. We also have another difference on nature of court hearing. Under CAP 76, the magistrate hears the extradition matter as nearly as possible in the same manner and with the same powers as a criminal trial court before a subordinate court. So the magistrate hears it fully. That is where we have an extradition agreement. But under CAP 77, the magistrate conducts committal proceedings to determine such matters as identity of the fugitive, whether the offense is extraditable, and whether the offense satisfies the statutory threshold. In either case, the extradition court does not conduct the person's criminal trial or determine ultimate guilt. Its purpose is limited to hearing the first instance and the second instance because it is testing on criminal duality principle. It is testing whether the crime has or whether the evidence satisfies the statutory threshold for such offenses that is also applicable in Kenya. Then you have final surrender. Under both statutes, committal by the court does not by itself complete the extradition. The actual surrender is an executive decision made after the judicial process and any prescribed waiting or challenge period. Under CAP 77, the AG decides whether to issue a warrant of surrender and may decline surrender where a statutory bar applies or where surrender will be unjust or oppressive. So that is the statute. Okay, in Cap 76 and Cap 77, you realize that the AG has powers in Cap 77 to decide whether to issue a warrant of surrender and may decline surrender where statutory bar applies or where surrender will be unjust or apprehensive. Okay, because we are testing on the principle of dual criminality. So the AG can decide, I'm not issuing a warrant of surrender against this person because the offense has not formed the particulars for it to be an offense in the Kenyan system. In as much as the court made a decision to surrender this person, we take the court's decision as an executive decision. Okay, and okay, it is a judicial decision, but we have to consider surrender as an executive decision, and the AG in Cap 77 reserves that right of making the final surrender. You will see this distinction clearly. Then we have challenge after committal. There is also a difference. In Cap 76, it provides mechanism through which the person may challenge detention or seek discharge before surrender. And under Cap 77, the court must inform the fugitive of the right to apply for habeas corpus, and surrender cannot ordinarily occur before the prescribed period has expired or while such proceedings remain pending. So take a look at how the two procedures are different. And if you look also at safeguards, under Cap 76, the applicable protections arise from the Act, the relevant extradition agreement and the Constitution of Kenya, while Cap 77 contains more express statutory safeguards, including restrictions relating to political offences, disciplinary protection, prosecution, previous acquittal or conviction, speciality, and circumstances in which surrender will be unjust and apprehensive. So I want you to appreciate that CLE was testing on Cap 77 procedure because they will tell you a procedure where a person is being required for political reasons, and they tell you that this person had also suffered a previous conviction in his home country. This is where you invoke the powers of the AG. Will I surrender this person even if I have submitted this person through the judicial procedure? And will I issue this warrant of surrender? Cap 77 tells the AG, look, you are analyzing the dual criminality aspect. If this person raises atrophies convict, you don't issue this surrender warrant. If this person raises political offenses that are not even political offenses in Kenya, or there is proof that he is being required in the country for political prosecution or disciplinary prosecution, automatically then the AG will not issue the warrant of surrender. So it is very important to have a distinction between the two. So in summary, Cap 76 governs extradition involving qualifying foreign countries covered by the necessary agreement and application mechanism, while Cap 77 governs Commonwealth countries formally designated under that Act. Under neither statute can a person lawfully be extradited merely because a foreign arrest warrant or Interpol red notice has been issued. The requesting state must comply with the applicable Kenyan statutory, judicial, and executive procedures. If you know about the great drug lord El Chapo, he was a resident in Mexico and he was being required in the American state for execution for purposes of dealing with illegal substances, and they had evidence that he was shipping a lot of cocaine into the country. So they attempted to arrest El Chapo and they had him in detention, and his advocates were quick and critically requested for this extradition agreement between the two countries. And at that time, Mexico did not have an extradition agreement because it could not have formulated an agreement in secret, because there is a procedure that is required in extradition agreements because it follows a gazette notice procedure. So Parliament had to sit within a short notice and prepare an extradition agreement, and that agreement was passed within 3 days, and it is from that passing of the 3 days extradition procedure is when El Chapo was transferred from Mexico all the way to USA and is now in undisclosed ile jail inakwanga ndani ya island, the most feared prison in America. So that is an overview of what happens, and we have a problem question. What if there is a conflicting position? We have an arrangement, we have an extradition agreement, and we are also a member of the Commonwealth. What should you do as a student? And the problem question before you, we are told that there is a Kenyan citizen accused of an offense committed in Tanzania, a country that is both contiguous to Kenya and a member of the Commonwealth, is arrested in Nairobi following an extradition request. The requesting authorities rely on an existing bilateral extradition agreement, while the prosecution argues that Tanzania's Commonwealth status determines the applicable procedure. So there is a conflict there. Now, advise the parties on which statute governs the extradition. Is it the Extradition Contiguous and Foreign Countries Act, Cap 76, or the Extradition Commonwealth Countries Act, Cap 77? In your answer, consider whether geographical proximity, Commonwealth membership, a designation or application order, or the underlying extradition arrangement is decisive, and compare the procedural requirements, evidential threshold, statutory safeguards, and authority responsible for surrender under each act. Will your answer change if Tanzania had not been formally designated under Cap 77? Hapa sasa examiner amekukamata nje na ndani. And the answer to that question is that the applicable statute is determined neither by Tanzania's proximity to Kenya nor by its Commonwealth membership alone. The decisive question is whether Tanzania has been formally designated as a Commonwealth country under Section 3 of the Extradition Commonwealth Countries Act, Cap 77, and the relevant designation order must therefore be produced and examined, including any limitations or conditions attached to it. If Tanzania is a designated Commonwealth country, the request must proceed under Cap 77. This follows because Section 3(1) of the Extradition Contiguous and Foreign Countries Act, Cap 76, applies only to a country other than a designated Commonwealth country under Cap 77. This one nataka ufungue masikio yako kabisa, because CLE haitambui kama haujui the difference between the two. Whenever the CLE individuals will tell you that there is a person in a Commonwealth country, okay, and these countries also have a bilateral agreement. Now you are in a conflict. Will I go with Cap 77 or will I go with Cap 76? Okay, Cap 77 is for Commonwealth countries. And for a country to fall under the Commonwealth countries, it should be designated under Section 3 of Cap 77. But you are told Cap 76 will apply only to a country other than a designated Commonwealth country. That is now the marking point. Tanzania's shared border with Kenya does not create an alternative route under Cap 76, and the existence of a bilateral arrangement cannot be used to avoid the procedure prescribed in Cap 77. So Cap 77 is to take precedence if that country is designated as a Commonwealth country under Section 3(1) of the Extradition Contiguous, is designated under Cap 77. So because 77 is for Commonwealth countries. Now, under Cap 77, Tanzania must make a formal request to who? To the Director of Public Prosecutions. Except in relation to a provisional warrant, the fugitive may not be dealt with under the Act without the DPP's written authority to proceed under Section 7. Nataka hapo nirudie so that we clearly understand, and we will clearly still understand nitty-gritties when we go further. Under Cap 77 on Commonwealth countries, Tanzania must make a formal request to who? To the Director of Public Prosecutions. Except in relation to a provisional warrant, the fugitive may not be dealt with under the Act without the DPP's written authority to proceed under Section 7. The request must be accompanied by the relevant foreign warrant or conviction documents, particulars of the person and offense, the applicable law, and the sufficient evidence to justify the issue of a warrant of arrest. The court must then consider, among other matters, identity, whether the alleged conduct amounts to an extradition offense, dual criminality, the evidential threshold, and the statutory bars to surrender. The Kenyan citizenship of the person does not by itself defeat an otherwise lawful extradition request, so it is irrelevant and immaterial to say about citizenship. The bilateral agreement may remain relevant to cooperation between Kenya and Tanzania, but it does not determine the applicable domestic procedure where Cap 77 will apply. Extradition is a coercive legal process affecting liberty, so the requesting state must comply strictly with a statute that confers jurisdiction. Neither a foreign arrest warrant, an Interpol red notice, nor diplomatic correspondence is by itself a lawful substitute for the prescribed Kenyan process. If Tanzania has not been designated CAP 77, the answer will change, because Commonwealth membership alone will not activate CAP 77 because Section 3 requires a formal designation order that is settled. And Tanzania will then potentially fall within CAP 76. But the bilateral agreement will still not be sufficient on its own, because under Section 3 of CAP 76, we are told that there must be an extradition agreement with Kenya, and the CS must publish a gazette notice declaring that the relevant part of CAP 76 applies to Tanzania, subject to any stated conditions, exemptions, or qualifications. So the order by the Cabinet Secretary must recite or embody the agreement, remain in force only for the duration of that agreement, and be laid before the National Assembly. Any applicable transition provisions under Section 27 of CAP 76 will also have to be considered. Did you hear where I was saying that Mexico and USA did not have an extradition order? Okay, and if there was an extradition agreement, the same cannot be enforced in secret. That's why the Cabinet Secretary had to publish a gazette order declaring the relevant part of CAP 76 applies to Tanzania. So this is exactly what happened in Mexico, because we are told that look at how National Assembly is coming into force. The order must recite or embody the agreement, remain in force only for the duration of that agreement, and be laid before the National Assembly. This is exactly what happened in Mexico. Any applicable transition provisions under Section 27 of CAP 76 will also have to be considered. So if there is no CAP 77 designation, CAP 76 application order, or applicable transition basis exist, the bilateral agreement cannot, without domestic legal implementation, confer extradition jurisdiction on Kenyan authorities. The court should not surrender the person merely because Tanzania is a neighboring Commonwealth state. So apart from the agreement, bilateral agreement, did you have the Cabinet Secretary order gazettement publishing a gazette order declaring the relevant part of CAP 76 applicable to Tanzania? So those are the nitty-gritties that I wanted you to have. So what is the governing legal framework? So we have principal statutes that I want you to master in this procedure, owing to the fact in time 4:53. So principal statutes is extradition from Kenya is principally governed by the following. You have the Constitution of Kenya 2010, in particular Articles 2, 25, 27, 28, 29, 47, 48, 49, 50, 51, and 165. The Extradition Commonwealth Countries Act CAP 77, the Extradition Contiguous and Foreign Countries Act CAP 76, the Criminal Procedure Code CAP 75 were applicable, the Evidence Act CAP 80, subject to the special evidential provisions in the extradition statutes, the Office of the DPP, applicable extradition treaties, agreements, and designation orders, the Fair Administration Action Act, the International Crimes Act, where a surrender to the ICC rather than extradition to a state is being sought. So those are the principal statutes that I want you to understand. Then we have the two principal extradition regimes, and the first procedural question is whether the requesting state falls within CAP 77 or CAP 76. Designated Commonwealth countries. The extradition Commonwealth countries, CAP 77, applies to countries formally designated for purposes of that act. Its principal features include a formal request being made to the DPP, a written authority to proceed issued by the DPP. Remember, it is a written authority. An arrest warrant or provisional warrant, committal proceedings before the extradition court, a right to apply for habeas corpus, and a final warrant of surrender issued by the Attorney General. Take a look at how Attorney General is coming and appearing last in CAP 77 by having the final warrant of surrender powers that will be issued by the AG. Well, the DPP played a very critical power by authorizing in writing a person to proceed, or the surrender, or not the surrender, the production of this person to be produced before the magistrate court or the high court. Then you have contiguous and other foreign countries. Now CAP 76 applies where the requesting country is covered by that act through the relevant statutory order, treaty, or arrangement. Its principal features will include a requisition through the applicable diplomatic or governmental channel, an executive direction to a magistrate, a warrant of arrest, committal proceedings before a magistrate, a 15-day period during which surrender cannot occur, a right to seek direction in the nature of habeas corpus, and a surrender warrant issued by the relevant cabinet secretary. Take a look at how the two procedures are different. In Cap 76, who receives this request? It is diplomatic or governmental channel, and this diplomatic channel to the government of Kenya is the AG. Okay, in Cap 77, it was the DPP to make an approval. But now, look at how the CS is proving to be of paramount importance when issuing a surrender warrant in Cap 76 on Contiguous and Foreign Countries Act. Now, when ICC tells you that they require a person, you don't subject ICC request to either of the two acts. A request by the ICC is dealt with Part 4 of the International Crimes Act, not under the Ordinary Extradition Act. The Act uses the term surrender rather than extradition. Under Section 39, the High Court determines eligibility for surrender by examining, among other matters, the ICC arrest warrant or judgment, whether the arrested person is the person named, whether the proper arrest procedures were followed, and whether the person's rights were respected. Accordingly, the procedure below should not be applied mechanically to an ICC request. Now, what are the preliminary legal requirements? So, we first go to step number 1. We confirm that Kenya has a legal basis for extradition. Before any substantive extradition proceedings are commenced, the responsible authorities must establish that the requesting country is governed by either Cap 77 as a designated Commonwealth country, or under Cap 76 through a statutory order, treaty, or arrangement, or 3. a bilateral extradition treaty, or 4. a multilateral convention capable of providing the necessary extradition basis, such as the ICC Act, and any other written law expressly authorizing surrender. So the file should contain all the relevant designation orders, treaty, convention, etc., and any reservations if applicable. A treaty or red notice does not by itself permit the executive or police to bypass Kenyan legislation and the constitution, even if the red notice is coming from the Interpol. Interpol is a combination of international security agencies that operate to fetch out cross-border criminals from each country. We saw a situation where Interpol came for 18 Kenyans who engaged in swapping banking cards belonging to United States of America citizens, and the surrender notice was issued, and they had to follow, had to abide to the laws of the United States. So we have seen some countries declining to enter into a bilateral agreement with the United States. We have the Arabic countries. That's why you will hear a person who is a notorious fugitive akitoroka aingie pande ya Arabian countries. He knows that the USA will not have jurisdiction in one way or another, and they must go through ICC if they want to be assisted. Now, step number 2 is identify the person and their location. The requesting state should provide enough information to identify and locate the person being sought. So they have to disclose the particulars of this information, because mistaken identity is a complete practical obstacle to extradition, and the Kenyan court must be satisfied that the arrested person is the right person being sought. Then you determine whether the accused is convicted or is just an accused person. So that was important because I told you we will have to make that distinction between the two, because if you are an accused person, the request will ordinarily require a foreign arrest warrant, charges, summary of facts. But for a convicted person, the request will ordinarily require judgment or certificate of conviction, sentence, and proof that the conviction is final or enforceable. And we are told that under Section 7.2 of Cap 77, the request should include, for an accused fugitive, an overseas warrant; for a convicted fugitive, a certificate of conviction and sentence, and a statement, sentence already served, and particulars of the fugitive. Then we go to step number 4. These are just preliminary steps. We'll have a quick overview of the same. Step number 4 is to confirm that the conduct constitutes an extradition offense. So the authorities must identify the offense under the applicable act, treaty, or designation instrument. So that is straightforward. They can confirm on double criminality. And for example, the usual question is whether the conduct, if committed in Kenya, will constitute a Kenyan criminal offense. The foreign and Kenyan offenses need not necessarily have identical names or statutory wordings. Then step number 5 is to screen the request for mandatory and discretionary bars. Before the authorizing proceedings, the DPP, the AG, Cabinet Secretary and Court as applicable must consider whether extradition is prohibited or should be refused. So we have potential bars that include: the offense is political in character. The request is intended to prosecute or punish the person for political opinions. The request is made because of race, religion, nationality, sex, ethnicity, or political opinion. The person may be prejudiced at trial or punished for an improper reason. Extradition will be unjust or oppressive because of delay. The offense is trivial. The accusation was not made in good faith, in the interest of justice. The person has already been acquitted, convicted, pardoned, or punished for the same conduct. The foreign proceedings are time-barred. The evidence is legally inefficient. The person is being prosecuted or serving a sentence in Kenya. There is a real risk of torture or cruel, inhuman, or degrading treatment. The person faces a death sentence for conduct not punishable by death in Kenya, and adequate assurances are unavailable. The requesting country will not observe the specificity rule. The person's physical or mental health makes immediate surrender dangerous, and the request is inconsistent with the Kenyan court order, or surrender will otherwise violate the constitution. So these are the discretionary powers and statutory bars that initially exist before mandatory disclosure or surrender. Under Section 10 of Cap 77, the High Court may intervene where, because of the trivial nature of the offense, passage of time, or absence of good faith in the interest of justice, surrender will be unjust or oppressive. Under Section 11 of Cap 77, the AG must not issue a surrender warrant where those considerations make surrender unjust or oppressive. Under Section 16 of Cap 76, surrender is restricted where, among other matters, the offense is political. The request is designated to try or punish the person for a political offense. The person faces a Kenyan charge or is serving a Kenyan sentence, or specialty protection is unavailable. So if the person is facing a Kenyan charge, that person will not be surrendered unless if he first finishes up with the sentence. If the offenses will not create a double jeopardy situation, then he will be surrendered. Then part 3 is where we clearly have to distinguish: are we going with Commonwealth extradition under Cap 77, or are we going with extradition under Cap 76? So for purposes of this presentation, we will deal with first the Commonwealth extradition procedure to avoid any kind of confusion. Then we will have to finish up with the other kind of procedure. So when you are subjected to Commonwealth extradition procedure under Cap 77, the request by the designated Commonwealth country, so it must be designated. And then you go to the next step, that the requesting country prepares the formal request. The requesting state should prepare an extradition request disclosing what is above your screen. And then the request is made to the DPP. Under Section 7 of Cap 77, a fugitive may not ordinarily be dealt with under the Act, except in relation to a provisional warrant without the DPP's written authority to proceed. Now, if it is a provisional warrant, we will not require the DPP's written authority to proceed if you read the clear understanding of Section 7, because you are told that a fugitive may not ordinarily be dealt with under the Act except in relation to a provisional warrant, okay, without the DPP's written authority. So this is to say, if the examiner tells you that we are seeking provisional warrants of this individual, the DPP's written authority will not be of paramount importance. So the request must therefore be made to the DPP by or on behalf of the government of the designated Commonwealth country. Diplomatic foreign affairs, police, and Interpol channels may assist transmission, but the statutory authority under Cap 77 still belongs to the DPP. The DPP examines the request, and it should verify that there is designation from the requesting country, the identity of the person, specialty protection, death penalty, delay or oppression, and other details. Under Section 7.3, the DPP may issue an authority to proceed unless it appears that a surrender warrant could not lawfully or will not in fact be issued under the Act. Now, the DPP now issues the written authority to proceed. If satisfied, the DPP issues a written authority to proceed. The authority should identify the requesting country, person, sort, offense or offenses, and status of an accused or convicted person. The authority to proceed is not itself an order for surrender. It just activates the judicial procedure. Okay, the DPP will issue an authority to proceed, but don't take it as an order for surrender, because now we have to go to the other step on arrest. So you apply for an arrest warrant after authority to proceed. So under section 8 of cap 77, a magistrate may issue a warrant following receipt of the authority to proceed. Under section 8, the evidence must be of the kind that will justify a warrant for arrest in Kenya for the corresponding offense or a person unlawfully at large after conviction. And this application should normally place before the magistrate authority to proceed, foreign warrant or conviction, affidavit, facts supporting the offense, and even location information. Then, provisional arrest in urgent cases. This is the exception to the rule. This is why you need to be very careful. Under section 8.1, a magistrate may issue a provisional warrant before the DPP's authority to proceed has been received, if information shows that the fugitive is or is believed to be in or on the way to Kenya. This procedure is used where there is urgency, such as imminent departure from Kenya. In fact, if you read the CLE paper, we were told that this person was at the airport. So when the examiner saw that you are now going to make a request to the DPP, automatically you have lost the 3 marks or 4 marks. Do you know that you are directly falling under section 8.1b, okay, of cap 77? Go direct to the point. Under section 8, there is a provisional arrest that is required in urgent situations. We have a flight risk here. It is a transit through Kenya. We are waiting for him to land. Risk of concealment. Delay in receiving the formal diplomatic dossier. There is imminent departure from Kenya. A provisional arrest should not become open-ended detention. Under section 8.3, the magistrate issuing the provisional warrant must immediately notify the DPP. The information and evidence must be transmitted to the DPP, and the DPP may cancel the warrant and must do so if the DPP decides not to issue an authority to proceed. So at the end of the day, the power still is reserved to the DPP, but we have already obtained the provisional warrant. That is what we are interested in. Then the DPP may either cancel later. Under section 9.4, the authority to proceed is not received. The extradition court may fix a reasonable period after which the person will be discharged. You see how it is tied to a certain kind of an activity on its own if that matter was urgent. Step number 12 is to execute the arrest warrant. Let's say the DPP has given the go-ahead, the magistrate court has issued an arrest warrant, now we are executing the arrest warrant. Under section 8.5, the warrant may be executed anywhere in Kenya by the person to whom it is directed or a police officer. At arrest, the person remains entitled to the protections in Article 49 of the Constitution, including the right to be informed promptly, to remain silent, to communicate, not to be compelled to make a confession, to be brought before a court as soon as reasonably possible, to seek release on bail on bond, and to challenge the legality of detention. Such preservation of evidential property. So under section 8.4, where the extradition request concerns thefts, receiving stolen property, or another property offense, a magistrate may issue a search warrant as if the offense had been committed in Kenya. You should purpose to listen to the video where we did the drafting of criminal charge sheets and charges, because we did it in a practical manner. So purpose to listen to the same, because sahi naanza kujua how to draft the same, even from my mental position where I am seeing a certain offense, like nimeona handling stolen property pale, nikafikiria hiyo charge venye inakaa. Now, first, court appearance, remand and bail. Let's say mtu ameshikwa, you must now bring the arrested person before the extradition court. Under section 9, the arrested person must be brought before the court as soon as practical. If first produced before a magistrate who lacks extradition jurisdiction, section 9.2 permits that magistrate to order that person be taken before a magistrate with jurisdiction, remand the person or admit the person to bail. Now, inform the person of the proceedings. At first appearance, the court should ensure that the person understands the country seeking the same, the alleged or proven offense, whether the arrest is provisional, statutory basis, the right to an advocate, interpreter, right to bail, right to challenge the identity. So the extradition court is not conducting the foreign criminal trial. So be keen, it is not for trial. It is determining whether the statutory conditions for committal and surrender have been met. That is the only powers reserved for this court. So we have bail and the demand. So we will do the topic on bail and demand, where we will also analyze the bail and bond guidelines to the details. We are told that bail should not be denied automatically merely because extradition is sought. Equally, the cross-border flight risk may constitute a compelling reason for strict conditions or retention depending on the evidence. Then we have advertise for a separate, that's a mistaken presentation. Then filing and disclosure of the extradition, where the prosecution files the committal material. The DPP ordinarily conducts or authorizes the presentation of the requesting case. Hapa kuna mix up kidogo, ndio inafaa kuwa ina appear first documentations. Give the person adequate disclosure and preparation time. So amefikishwa kotini, apatiwa time for preparation. Then we have committal hearing. Now this is where we are back on track. Committal hearing, where the court conducts the committal proceedings. Under section 9.3, the extradition court has, as nearly as may be, the same jurisdiction and powers it has in a trial. So the hearing should ordinarily proceed as follows. The prosecution identifies the authority to proceed, designation and legal basis, foreign documents are produced, identity evidence is presented, evidence supporting the offense is presented, the requested person raises objection and evidence, witnesses may be called. So the court does not determine guilt or innocence in the same manner as the evidential trial court. Ukianza kuleta mambo ya kuchukua plea, hapa umeanza kubant. It decides whether the person is legally liable to be committed to await surrender. So that is it. Threshold for an accused fugitive. Under section 9.5, the court must be certified that the evidence will be sufficient to warrant the person's trial for the corresponding offense if it had been committed in Kenya. And the threshold for a convicted fugitive is that under section 9.5b, the court must be certified that the person was convicted of an extradition offense, the conviction documents are properly proved, the arrested person is the person convicted, and the person appears to be unlawfully at large. So we have to test for whether you are being sought or you are a fugitive escaping conviction. The decision to commit or charge, if the court is satisfied that the statutory requirements are met and no prohibition applies, it commits the person to custody to await surrender. Then, if the court is not satisfied, it must discharge the person. Then habeas corpus and post-committal protection. Court informs the person of the right to habeas corpus under section 10 of cap 77. Once the person is committed, the court must inform the person of the right to apply for habeas corpus and immediately notify the DPP of the committal. Habeas corpus is also protected by Article 25D of the Constitution of Kenya as a right that cannot be limited. Then, still on it, we discussed on a webinar, when you're doing habeas corpus applications, how will you deal with the petition itself? Do you do a notice of motion and supporting affidavit, then you call yourself that you have mastered the same, or will you still proceed to do the petition? It's highly advisable for you to look at the video on habeas corpus applications, exactly what the examiner requires from you. Then there is a 15-day bar against surrender. So this is just automatic. You will not be surrendered immediately, because section 10.2 says that the person must not be surrendered until 15 days have expired from the committal order. While a habeas corpus application still remains pending, you will still not be surrendered. So the 15 days are a minimum protective period, not a direction that surrender must automatically occur on the 16th day. So file habeas corpus proceedings in the High Court, and outcome of the High Court application will be made, and then your fate will be cooked. Your fate will be cooked, because this zingine is a executive decision and surrender warrant. So the file, after sasa imetoka court, habeas corpus application yako imekuwa determined, the file is transmitted for what? Executive consideration that we said. And this executive consideration, we said, inaenda kwa AG, who will consider whether to issue the warrant. Under section 11 of cap 77, the final warrant of surrender is issued by the AG subject to the act. So the AG must consider, among other matters, whether surrender is prohibited, whether the person is charged or serving a sentence in Kenya, whether surrender is unjust or apprehensive, death penalty implications, competing extradition request, seriousness and dates of request, citizenship and ordinary residence, health, speciality, assurances given by the requesting state. So in this situation, kulikuwa na hiyo CLE question where kulikuwa na competing requesting states. So kulikuwa na the earlier in time na kuna ingine later in time. Kuna ingine yenye ni home country, ingine ilikuwa a foreign country yenye ametoka alafu anakuja kuland in our Kenyan airport. So it is a very technical question, na ikirudiwa watu wengi wataanguka. Then postpone surrender where Kenyan proceedings are pending. So if you are told again with the factual matrix that we have a pending Kenyan proceeding, that Kenyan proceeding must be heard first, then this surrender will still be postponed, but you are not free. You are not free from surrender. And you should address health-related postponement. It can be postponed because of medical reasons. Then you'll be addressed. Then you'll be surrendered after your medications. Then you have physical surrender that will happen. So that ukishafanyiwa physical surrender, you hand the person to authorized receiving officers and enforce the specialty principle, where the specialty rule ordinarily requires that the person not be tried, detained, punished, or re-extradited for an earlier offense other than the offense for which extradition was granted, unless Kenya consents, the applicable treaty permits it, the person has had a lawful opportunity to leave the requesting country but remains, or another statutory exemption applies. So the requesting state should therefore be provided with a surrender warrant and the exact offenses for which surrender was granted. So kama wanamshika tena kwa separate reason, Kenya must consent to that because it issued a surrender that was specific for a certain offense. Let us not deal with extradition under Cap 76 because that is a separate procedure and you are likely to be confusing terms if we are to go into that route. Let me end this recording, then we do commercial litigation paper 2026. At least we introduce the same and mark it as a part A of the same. How did you find the session? You can be making the comments as I